सर हो गया है
हो गया तो इंफ्रक्चर्स हो गया केस आपका।
जी
अगर जजमेंट हो गया नीचे तो
जी।
केस खत्म हो गया अब आपका।
अ,
फिर आप
अ,
अपील फाइल करिए अब।
सर अपील फाइल की हुई है
हो गया
सर।
तो इससे ये इंफ्रक्चर्स हो गया अब।
जी
अब ये किसी काम का नहीं रह गया है आपका केस।
जी।
अगर जजमेंट होने से पहले सुनवाई हो गई होती
हाँ
तो कोई आदेश हो जाता।
नहीं सर, फाइनल जजमेंट नहीं हुआ है सर इसमें अभी।
फाइनल नहीं हुआ है,
नहीं
इसमें
नहीं।
20 3 को लगा था।
नहीं सर, नहीं हुआ है उसमें अभी। सर एक्चुअली मैं प्रिपेयर्ड हूँ सर, आप बोले तो मैं
नहीं नहीं,
पूछ
पहले तो
सकते हैं।
पहले आप ये बताइए कि
जी।
केस फाइनल हुआ है कि
नहीं
नहीं
नहीं,
हुआ।
नहीं हुआ है सर अभी। आगामी पेशी
कब है?
29 तारीख की है सर इसमें।
29।
29 मार्च।
29 मार्च तो निकल गया।
सॉरी 29, ये अभी आने वाली 7 अप्रैल को है सर।
7 अप्रैल भी निकल गया।
7 अप्रैल आने वाला है सर, 7 अप्रैल।
चलिए बहस कर दीजिए, बताइए।
सर आई लॉर्डशिप ऑन द डेट ऑफ 6 मार्च
नहीं,
2025।
आप ये बताइए, आप जब फाइनल आर्गुमेंट में लगा था तब आपने
नहीं
अमेंडमेंट संशोधन का आवेदन क्यों
सर,
पेश किया?
ये यही तो गलत है सर कि हम हमारे द्वारा जो है सर वो माय लॉर्ड ऑन द डेट ऑफ 6 मार्च 2025 इट इज रिटन ऑन द ऑर्डर शीट एनेक्सर पेज नंबर 13 to 15 by the honorable 10th ADJ that the application of order 6 rule 17 has been given by the petitioner at 4:30 p.m. whereas the application was given by the petitioner before the 10th ADJ on 6th March 2025 in the morning time near about 11:30 a.m. and after giving the application the petitioner had left the court premises, and it is also written in the order sheet that 6 March 2025 that the final argument has been heard, whereas on the 6 March no argument made by the petitioner, neither the plaintiff and defendant argued with each other, nor that petitioner present her argument separately, or neither submitted any written argument. Despite this, the Honorable 10th DJ has unnecessarily passed the controversial order and deprived and snatched the petitioner opportunity to file the application of Order 6 Rule 17 with Section 151. In this regard, we also demanded video footage of 6 March before the Honorable Principal of District and Session Judge of Bilaspur, regarding which I want revision of my application of Order 6 Rule 17 in this Honorable Court through a writ petition. We also file an application for interim relief stay on page number 10 and 11. Therefore, Lordship, I humbly prayed in both ways that you set aside the order dated on 6 March 2025 or grant a stay on the civil suit. Case number is B3 2018. Proceedings going on in the 10th ADJ till the writ petition is decided.
हो गया।
जी
बस लिखिए मिस्टर दी अग्रवाल through power petitioner in person through power of attorney. The petitioner has petitioner. The defendant has challenged order passed by 10th Additional District Judge Bilaspur dated 6/3/2025, passed in civil suit B/3/2018, whereby an application moved under Order 6 Rule 17 of CPC has been rejected on the ground that it was moved at final hearing stage. The learned counsel for the learned counsel, Ms. Agrawal would argue that application for amendment was moved on 6th of March 2025 at about 11:30 hours. But the learned court below recorded a finding that it was moved at about 4:30 p.m. and thus the finding in this regard is erroneous. She would submit that the petitioner has right to move application for amendment at any stage. Then the learned trial court ought to have considered this aspect. She would also submit that the plaintiff wanted to insert certain facts which could not be brought in the written statement. She would submit that the petition may be allowed. I've heard Ms. Agrawal and peruse the documents. The petitioner has not annexed copy of planned and written statement. An application moved under Order 6/17 read with Section 151 of CPC has been placed on record as an Exhibit P2. Application would show that the petitioner proposed amendment to the effect that the plaintiff failed to take steps with regard to regularization of double-story building. And when he came to know about the valuation of the property, he did not give his consent. It is also pleaded that it is also stated in application that the collector valued the valuation of property to the tune of found the valuation of property rupees 27 lakhs insufficient and rejected the application for grant of permission. Next, perusal of the order would show that perusal of the impugned order would show that after completion of trial, when matter and after completion of trial, when case was set for judgment, application for amendment was moved. Next. It appears that the petitioner was aware of these facts at the time of filing of written statement, but no steps were taken to move application for amendment, and application was moved at the fag end of trial. It is informed by petitioner that case is set for judgment on 7th of April 2025. Take into consideration the above stated facts, I do not find any illegality or error of law in the order passed by the learned trial court. Consequently, this petition fails, hereby dismissed. Next.